Good afternoon to everyone in Good afternoon to everyone in Radio Land. We'd like to welcome you to a brand new weekly edition of the program What the Law Says. As you know, What the Law Says is your premier radio online platform for legal education and legal scholarship. We air here on ELBC every Tuesday with a fresh and brand new edition from 3 to 4 p.m. We also are being streamed live on LNTV on Facebook. For those of you who are not on radio and would like to follow the program on Facebook, you can follow us on LNTV Live. In addition, you can also follow us on my own Facebook page, Cllr Kanio Bai Gbala, and you'll be able to view and listen to this program. So what's the basic rundown of our conversation today? We'll pretty much very quickly look at the key topical issues that we are going to address today on What the Law Says. And this is part of, in fact, this is like the final segment of what I term as the foundational conversations we are having before we begin to go into what lawyers would term as more substantive law issues, meaning looking at actual laws, whether it be land or inheritance. So today we're going to firstly do a brief recap of the last edition. After that recap of the last edition, we'll look at what we term as indispensable legal principles. These are very important because as we begin to talk about the different laws and how they apply, it's always important to keep these principles at the back of your mind as you deal with the issues that will arise. So it's important for us to talk about these legal principles. And then finally, we will close by looking at the broad classifications rather, of law. And I believe it is from those classifications now in our following edition that we'll begin then to look at substantive law issues, meaning looking at the different laws that exist. So we'll take a few more bars of our theme song. After that, when we come back, we'll delve straightly into our agenda for the day. Keep listening. Welcome back to the program, What the Law Says. So, as we indicated earlier, today we're going to do three things. Our agenda consists of three basic, not very, very basic, but I mean, these are the topics that underpin the presentation today. The first topic we're going to address is very quickly, we'll do a recap of the key issues that came out of the last session we had on the program, What the Law Says. Then we'll look at in detail what we term as indispensable legal principles, because these are principles that underpin your understanding of law issues. These are principles that every time you're faced with a situation where law is involved, that should guide the kind of thinking we have about those issues as well. And then finally, we'll look at the different classifications of law. And I believe that by the time we're done with these three, which is the last program in terms of the foundational series that leads us to talk about substantive law issues, I mean, we should be in the right place now to begin in the next edition by looking at particular legal issues or laws within the Liberian jurisdiction. So let's start by looking at our recap. I believe the last time there were two major issues that came out of the last presentation. The first was we talked about the Liberian legal system, which we said at the time basically comprises all of the different organs of the state that collaborate together in order to deliver justice or the legal processes in our country. However, even though we argued that all of those different branches, be it executive or legislative, have a role to play in regards to law, however, it was the judiciary that played the most important role because it explained or clarifies law, and that is its function. And within that function, there are a series of courts created to address that judicial function, starting with the Supreme Court, specialized court, circuit courts, etc., and ending with the magisterial courts, which are at the lowest level of the court system. And then we talked about the sources of Liberian law, meaning it was important if you're embarking on a conversation about law in our jurisdiction that you ought to know where we get our laws from. In other words, you ought to know what are the sources of our law. And in talking about the sources of our law, we cited one primarily in order of hierarchy, meaning from the topmost to the least binding. You start off by looking at the Constitution as being the primary source of our law that no other laws should contradict. Then we talk about statutes, we talk about legislation, we talk about delegated legislation. We also talk about ordinances, the common law, and then we ended by talking about case law. And we ended on case law, not because case law is less important, but as we said, because case law is basically law in action, and it is law that is controlling, that it is law that is derived from when the Supreme Court speaks about a particular issue or interprets a law, and therefore it is very, very important. So if there are two out of the last session of what the law says, was basically that one, what is the legal system of Liberia comprised of? And two, where do we get our laws from? Now, having said that, what is basically are we focusing on today? What is the substance of our conversation today? Today we're going to start by looking at what I term, some others will refer to them as key principles, but I refer to them more or less as indispensable legal principles. Indispensable because I think you should not be able to do without them. Whether you are a lawyer or a lay person, and if you involve in the process of understanding how the judicial sector works, it's important for you to always keep these principles at the back of your mind. When any controversy or issue arises that law must address, it's important for these principles to be first and foremost underpinning how you understand those issues and how the court goes about dealing with those issues. And that's why we refer to them as indispensable legal issues. We've itemized a number of them, but we'll start with them in that particular order. The first indispensable legal principle we want to talk about today is the one called due process. And with due process, I think more or less you may have heard this term repeated before in different types of conversations. That tells you how important this particular principle is of due process. But what is due process in legal jurisprudence? And in fact, what is due process defined as in our own laws, in case law? Now, scholars tell us, according to various research, etc., that due process is basically the idea that when a case or when an issue comes before a tribunal or a court to be handled, and the state represents the legal system, that there are certain rules that apply or principles that apply that are designed to guarantee the rights of those who have been accused or those who have issues before the court or those who have brought issues before the court. Due process says that in order for those things to be heard, those rules ought to be respected. Those rules ought to be followed. And if they are not followed, it could lead to a violation of rights. And that's why you hear people saying, there's no due process. Oh, I didn't have due process. So what is due process? It's basically that there's a responsibility of the state as represented by the judicial sector that anytime there is a violation of law or there's an alleged, I should say, violation of law, that you will apply principles and rules that tend to respect the rights of those who are accused. Now, that's generally speaking about due process. But again, we go further to subdivide them into different categories. So there are basically two general categories of due process. The first category is what we refer to as substantive. And if you just go by the word substantive, you know that it means that we look at the substance of the law. And for example, if a law says that the act of murder is picking up a cup and slamming it on somebody's head, that is the law. Now, giving someone due process by substance will mean that before you convict a person of murder, they must have picked up a cup and slammed it on somebody's head. That's an elementary example of what due process substantively will look like. Now, the other aspect of due process is what we refer to as procedural. Now, procedural due process has to do with the process, obviously, through which we access the court system. The whole idea is that to go to court, someone must be sued, papers must be filed. In cases where it's a court of no record, a complaint must be made orally. Now, no court should be able to find somebody guilty of something if those processes have not been followed. We tend to describe the situation wherein such processes are not followed as it being jungle justice. So, on the substantive side, we're saying that it is the element or the letter of the law defining what is the crime or what should be wrong that the state must follow. Whereas on the procedural side of due process, we say it is basically following the rules of court or the rule of any tribunal that is supposed to investigate. How are those rules laid out, right? So that's by definition. Now let's look for an example just to look at how our own case law. Remember I told you before that case law is so very important because it tends to show you the law in action. It tends to look at laws that are written in books that anyone can read, but then to see how the Supreme Court, our Supreme Court, has held or has dealt with the question or answered the question. There's a particular landmark case in Liberian jurisprudence, which is so landmark in the instance that it has been the basis for defining what due process is. And that case is called 𝐻𝐻𝐻 versus 𝐻𝐻𝐻. It was argued, the ruling was handed down in 1937 by the Liberian Supreme Court then. And it basically defines due process as one, due process is the law of the land, which means that in any processes within the Liberian jurisdiction that involves law, that people or courts are under obligation to follow due process. The second thing it says is that due process is the law that hears before it condemns, which means that if there's an allegation made against somebody, before a condemnation or a verdict can be reached, that person ought to have been given the opportunity to be heard. It goes on to say that due process proceeds upon inquiry, which means that before you reach a conclusion, you must inquire, that you must find out, that you must employ certain resources to understand what transpired, and on the basis of what you find, then you can make a decision. And then finally in 𝐻𝐻𝐻 versus 𝐻𝐻𝐻, our Supreme Court also said that due process only renders judgment after a trial, which basically means that in order to finally make a decision that is binding by law as to the conduct of anyone for that matter, due process requires that there must be a trial, that there must have been a process of confronting people, presenting evidence, going through that process, and then eventually a court or a tribunal or any organ that sits quasi-judicially, meaning like a court, can then reach a conclusion. So what is due process? Pretty much in 𝐻𝐻𝐻 versus 𝐻𝐻𝐻, our Supreme Court put it out there that it is the law that hears before it condemns, it is the law that proceeds upon inquiry, and it is the law that only renders judgment after trial. Now, what's the second indispensable legal principle one wants to keep in mind as we proceed in this study of law that we've embarked upon on radio and online? The second is the question of proportionality. Proportionality, primarily in criminal law, we say is that punishment should fit the crime. And I'll give you an example. If you live in a house and your smaller brother decided that in addition to eating his food today, he will also eat your food, which I believe is a transgression, meaning it's a wrongdoing. He shouldn't do it. He had his food, but he also decided to eat your food. Now, if you came home and you reported the matter to your parents, what do you think will be a just punishment for that smaller brother or sister of yours? That example basically illustrates the whole principle of proportionality. That courts, when handing down rulings for issues that are brought before them, assuming people have been found liable or guilty or found wanting in the eyes of the law, then their ruling or whatever sanctions they come up with ought to be proportional to what the transgression is. As we normally say in ordinary speak, you don't use a hammer to kill a fly. Also, in proportionality means that if the crime or the gravity of the crime is lower, therefore the punishment also should fit it and may understandably be lower. But if the gravity of the crime is higher, then therefore punishment should also be higher. And that's the idea of proportionality. The third principle I like to talk about is what we term as the presumption of innocence, and I like to bundle that conversation of the presumption of innocence with the burden of proof. Now let's pick these words apart very quickly so that we get a sense of what they mean. When presumption basically comes from the verb presume, and when we presume, it means that we assume a certain thing, even though we don't have the facts yet. We say that, okay, I will think that this thing is what it is. So when we presume, we take a particular position, right? So if we add that to presumption of innocence, innocence meaning someone who is not guilty, someone who has not been found wanting in the eyes of the law, we're basically saying presumption of innocence is an assumption, or we will want to think that this person is innocent, or whoever is accused is innocent. Burden of proof, on the other hand, has to do with who is responsible to prove or to provide the evidence that this person is guilty or not. This whole idea of presumption of innocence and burden of proof is a very, very important and critical legal principle that underpins our judicial sector. Because our laws provide that anyone who is accused is assumed or presumed, as we say, to be innocent until they are proven guilty. That it doesn't matter the nature of the allegations or the nature of the accusations or how many they are, until those accusations or allegations are proven, persons or person groups involved are considered to be innocent. And that's the whole idea or principle that underpins our law. It goes further to say that the burden of proof normally rests with the state or with the prosecution or with the accuser, that whoever brings these allegations have a responsibility to prove them. We go on to say that when it is a criminal allegation, we say the burden of proof is what we refer to as beyond a reasonable doubt. And I will talk about that shortly. When it's a civil allegation, we say the burden of proof is the preponderance, rather, of evidence. Now, beyond a reasonable doubt basically means that when you accuse somebody and they go to court and the court has to hear the matter, that there should be no shred of doubt in the mind of those who are hearing this matter that the person is guilty before they can find that person guilty. Once there is any issue that leaves the judge or the jury sitting with any doubt as to the fact that it may have happened or it may not have happened, we say according to law that they are under obligation to acquit or to find the person not guilty. However, for them to find anyone guilty, they must make sure that it is proven beyond a reasonable doubt. And that's for criminal matters, matters that involve crimes. For civil matters, meaning they are private wrong, these are not criminal matters, we say preponderance of evidence. In this case, we say the burden of proof is lower, that once that there are many persons claiming, and I'll give you a classic example before we move ahead beyond this principle. Assuming someone is accused of murder, which is a crime, and 10 persons came and gave testimonies and say, oh, we saw this person around, we saw John around Mary's house. And then the next morning, Mary is dead. And 10 persons keep repeating that John is there, John was around, we saw him there, and before he left, he had an argument with Mary. Now, that kind of evidence, but none of them can say that John actually killed Mary or they saw John engaged in that act. If it went to court, there is still some level of proof to be adduced or to be given before the court, which is a question of beyond a reasonable doubt. Because if even 10 persons said, we saw John around and they had an argument, one person could still be thinking, what if after they had the argument, John left and someone else came there? So the law provides that once there is a reasonable doubt, or a doubt that anybody who can reason has about that issue, John should be found not guilty. It's not about how we feel, right? That's the whole idea of the burden of proof in regards to the presumption of innocence. However, if it's a civil matter, we say we talk to preponderance of evidence. Meaning, if it's not criminal, maybe, it's a question of John went to Mary's house, he knocked down her fence, or it's alleged that he knocked down her fence. 10 persons came and said, we saw John around, John was driving a bulldozer, it appears that he the one knocked down the fence. That's an example of a preponderance of evidence with many persons saying that in a civil case, John may be held liable. Whereas in a criminal case, using the same standards of having 10 or more persons giving evidence, John may be found liable in a civil case, but in a criminal case, John may not be found guilty. So what does this say? And I gave you one case in our jurisprudence, one or two cases that talks about presumption of innocence. Our Supreme Court held in the case Cllr versus the Republic, named 28 LLR, that an accused in a criminal case is innocent until proven otherwise. There are no point during accusation of whatever crimes that have been committed. In Cllr versus the Republic, our Supreme Court, which, like we told you before when we talk about the sources of law, Supreme Court sits at the top of the chain and basically dictates what the law is, that until someone is proven guilty in a court of law, that they are always innocent. Also, from the Supreme Court, we have another case there that speaks to this whole idea, Eldane versus the Republic of Liberia, 27 LLR 133, and that's just a way to be able to locate these cases. And it says that to overcome the proof of innocence, guilt must be established beyond a reasonable doubt. And that's the example I gave you of what represents reasonable, beyond a reasonable doubt, as opposed to what represents the preponderance of evidence. The next legal principle I like to talk about is the principle of what we term as precedence or stare decisis. Basically, precedence or stare decisis in our jurisprudence is the idea that cases that are similar in nature or raising similar issues ought to be decided similarly by the courts because we want to ensure fairness and equity. In other words, if Kanio is accused of something and he goes before a court and the court finds him not guilty based on certain laws, and Moses is accused of a similar thing and goes before the court should also follow the same logic it used in Kanio's case because it's a similar matter and find Moses not guilty or not liable. Because to do otherwise would be to undermine fairness and equity. And that's what we refer to as the principle of precedence or stare decisis. Again, our court in the case Powell versus Deputy, which is 30 LLR 311, the Supreme Court said that the Supreme Court, basically, the decision of the Supreme Court rather, stands as a rule or a guide for deciding similar cases until the ruling are recalled. Basically saying that once the Supreme Court makes a decision, the logic of the Supreme Court should be the logic that all other courts will follow in handling similar matters that come before them. Now let's look at this next principle before we take a very short break, and then when we come back as we move along, we'll open the line. The next one we want to talk about is what we call separation of powers. And I'm sure some of us may have heard separation of powers before. The whole idea of separation of powers is based on how the Constitution set out the framework of our government. It created three different branches of government, executive, legislative, and judiciary, and it gave them various roles to play. The whole principle of separation of powers says that while all of these branches have their role to play, no branch should usurp or take unto itself the function of another branch. And for any branch to do that, to violate the whole constitutional principle or legal principle of separation of powers, it will be that they will be acting unconstitutionally. And it's very important to keep that in mind as you study law or as you go through understanding these cases. A particular case, again, that illustrates this, I know I cited this before, but in the same case, Wallow versus Wallow, the Supreme Court was very clear as to say that no branch of government shall usurp the functions of the other, and that the judicial functions of any government, meaning deciding cases as well as making determinations about controversies between people who have those issues, shall be vested solely within the court. Now, finally, before we go on our very short break, and then when we come back, we'll open the lines, let's talk about equal protection. Now, equal protection is another constitutional principle or legal principle. And it basically argues that everyone who lives within a country, citizens of the country, are guaranteed protection by the laws of the country or by the Constitution and all laws that govern conduct within a country. And equal protection basically argues that nobody should be denied of a protection that others enjoy, that everyone should have that protection from law equally, and is a basic legal principle. Again, in our case law, basically, equal protection in the case of the Republic of Liberia versus the leadership of the Liberian National Bar, 40 LLR at 635, argues that, again, no groups of people shall be denied protection that are guaranteed to others under our laws, and that therefore the state and the judiciary has a role to ensure that all citizens under its jurisdiction are provided equal protection. At this point, we'll take a very short break and then we'll open the lines. If you have an interest in participating on the show through questions or comment, the line to call is 0880-514-096. I repeat the line, 0880-514-096, here on ELBC. And the program is What the Law Says. When we come back, we'll start taking calls as we wind down on other outstanding aspects of the program. Welcome back to What the Law Says, and as we indicated, the lines are open if you have questions or comments or whatever submissions to make. We'll be glad to take them. I think we have a caller on the line already. Hello? Hello? Hello, please state your name and where you're calling from.
Good afternoon. My name is Harrison M. Johnson, and I call from Cllr.
Welcome, Harrison. Please state your concern very quickly.
Okay, I'd like to know the difference between criminal case and the civil case. And an example, sir, please.
Thank you very much, Harrison. Well noted.
You're most welcome.
Okay. So we have that question from Harrison that we'll respond to when we get a few more questions that come in. What's the difference between criminal versus a civil case? We'll firstly conclude quickly these constitutional principles and then we'll respond to, do we have another call on the line? Let's take that call as well. Hello?
Yeah, hello?
Your name and where you call from?
Okay, Counselor, I'm 𝐂𝐫𝐢𝐞𝐟 from where? I join you from Brooklyn, Ghana City.
What's your concern, Dominic?
All right, thank you very much for the program. I really admire your exposé. And my recommendation is still radio. You know, some of us sometimes we can make the program and then we try to download the video from the Facebook to our feed because some of the videos are not complete. So we want to really extend that to them to try and make that video complete so that we will follow all the story. Thank you very much.
Thank you, Dominic. Your concerns are well noted. Do we have another caller there? All right, so let's conclude this quickly, then we come to Harrison's point. At least if we get 2 or 3 more questions, then we can respond to all of them. We have another call on the line. Hello?
Yeah. How you doing?
Very well. Your name and what's your concern, please? Very quickly.
Well, I'm Maxwell Tony, and I've been following you since the beginning of this program. And I just called to appreciate you also for what you are doing, especially for those who have interest in the legal fee. I'd like to thank you for the education. Keep it up. Thank you so much, sir.
Thank you, Maxwell. So we were at indispensable legal principles. We just talked about equal protection. So we're close on this by talking about no rights are absolute. That's the final principle, and then we'll respond to Harrison's question before we move ahead with the classification of law. So the whole concept around no rights being absolute are, in any jurisdiction, citizens are guaranteed certain rights. We call them fundamental rights. For example, the right to liberty, the right to free expression, and all of those rights that we always like to label as human rights. But what we forget is that these rights can be limited or enjoined, as we tend to say as lawyers, by government for certain purposes. So that's why you will hear where your right begins is where someone else's, your right ends rather, where someone else's right begin. That you have the right to free speech, but to the extent that your speech injures someone by law, we can stop you from speaking, or we can sanction you because of speech. Or to the extent that you are free, but your freedom does not extend into the private property of another person. So all of those incidents highlight what we refer to the fact that no rights are absolute. This brings us to the end of our indispensable legal principles, and very quickly we want to lay them out. We started out by talking about, firstly, due process as the law that hears before it condemns. Then we talk about proportionality, that punishment should fit the crime, not larger or smaller, but proportional. We talk about the presumption of innocence, that anyone accused until brought before a court, as we always say, of competent jurisdiction, and given the opportunity to exonerate themselves, until such a point that person is innocent, and the burden of proof rests on those who are accused or on the state. Then we talk about precedence or stare decisis, which is that courts are under obligation to treat cases with similar instances utilizing similar logic or rules as they did before to ensure fairness and equity. Then we talk about separation of powers, that there are 3 branches of government. They all have distinct roles, but the judicial function, meaning hearing cases and deciding cases, rests with the Supreme Court or with the court system or the judicial branch. We then talk about equal protection, that all persons are guaranteed equal protection of law no matter who you are. And finally, that no rights are absolute. Now that brings us to the end of these indispensable legal principles, which, like I said before, is about putting us in a foundational space that enables us now, when we begin to talk about the substantive law, we can begin to deal with that. Now, Harrison asks a question that basically speaks into where we're heading now. The question is basically, what's the difference between criminal versus civil law? What makes a case criminal? What makes a case to be civil? Now, there are 2 or 3 ways to look at this. The first way is that all acts that are criminal because the laws in a particular country designate them to be criminal. It lays out or it identifies certain conduct that it finds to be so offensive, so repugnant, as we say, against the consciences of the people, so uncivilized that we label it to be criminal. And that's the easy definition. Another way to define criminal could say that it is against actions that are committed against the state, because the state views those kinds of repugnant, disgusting, unconscionable actions as being acts that are not just committed against a person, but against the whole state as a whole. And then the final way to define what makes a case criminal is the fact that there exist two major components. The first one in law we tend to refer to as the mens reas. The mens rea basically means the mentality, and I will explain that. And the other one refers to what we call the actus reus, which means the action. Now, in a criminal case, we say that there is intention, that whoever commits a crime must have thought about this crime, which is the mens, and you can see the relationship between mens and mentality, or mentor, meaning it has to do with the mind. They must have thought about it and conceptualized it and planned it within the realms of their thinking. Then they must have moved on to act upon it, which is the actus reus. So there's the mentality and there's the action that makes it criminal. Whereas in a civil case, we say it is basically a dispute that is between two persons. They are private. It's not between the state and that person. And such actions have not been labeled as criminal. So most times you'll find in criminal cases, there is action, meaning there's the actus, but there isn't the mentality or the intention or the means to do it. And I'll give you an example. Take, for example, and these are two examples that could be either criminal or civil, depending on the presence of the mentality or not, right? So you take the question of murder and you take the question of manslaughter. If you look at murder, the key components basically is the taking of life, as the law says, willfully, with malice aforethought, right? So you go out there, there's a mentality that you're going to take a life, you conceptualize it. I don't like this person, I find them offensive, and I will go on there tomorrow on that road that I know where they always pass, and I will hide in wait, and when they show up, I'll kill the person. So you start out with a mentality, and you go ahead and you effect it by action. So mentality versus action, mens versus actus, produces a crime. But I can give you a same case where you just get in your car and you're driving, and someone is crossing the road, and you're driving and you don't know this person from anywhere. You never anticipated that you would see them on the road, but you're speeding, and therefore there's an accident, and without any kind of premeditation, as we say, this person dies. Now, two cases where you have the loss of life. Someone died, but one gets classified as a crime and the other gets classified as less of a crime, which illustrates the whole idea of mentality being central to cases being criminal as well as cases being civil. So again, that brings us where I was. And the lines are open, like we said before. If you want to participate or ask questions, you can call on 080-514-096, and you'll be able to ask questions or to make comments to the program. But that brings us then to our final component of this foundational series, which now prepares us to move on and talk about substantive law, which was the classifications of law. And Harrison did a good job of preempting that and asking this question. So there are, in my view, there's a lot of discussions about what is what, but in my view, there are three broad classifications of law, or I would say six, but again, it's about tit for tat, so three broad classifications of law that I believe almost every form of law will fall nicely into. The first is what we started off by talking about, the criminal law, which is basically laws that relate to what we call as crimes. And in the case of crimes, we say that one, someone possesses the mentality, followed by, which is the intent, followed by action, and then society labels that as criminal in nature, and that's the criminal law. And then on the other hand of that is what we call the civil law, which are laws that relate to private disputes between individuals and groups. Now, what are some of those kinds of private disputes? We have contracts that have gone sour. I've contracted you to build a house for me. I've paid you some money. Over the period of time you've not built the house, neither have you refunded me the money. It's a dispute between private individuals, and it falls within the realm of civil law. There's also the case of torts, which are private wrongs, like someone destroys your property, not criminal in nature, unintentionally. Therefore, it is a private wrong and falls under the realm of civil law. So that the first two major classifications of law are basically criminal law and civil law. Now let's move to the next two. The next two are what we have substantive law and then procedural law. Substantive law basically are about laws that defines the rights themselves. So we have a law that talks about the Constitution, for example, talks about human rights, rights that all Liberians should enjoy. We have a law that looks at contract rights, or commercial law, the Liberian commercial law, which basically lay out the rights that are there for people who are involved with the buying and selling of goods and services. All of those are examples of substantive law. Laws that govern traffic, juvenile behavior, or substantive law. And then on the other hand of substantive, we have what we refer to as procedural law. And in the case of procedural law, we say basically these are the laws that prescribe the procedures of how we bring cases to court, what you must do in order to access the courts, and the steps that one must follow if one must get access to the courts. So, for example, an example of a procedural law could be rules on appeals. I remember in the last program someone asked about appeals and say, when is it, how do you appeal, or the period for appeal? The law provides that when you come from a circuit court, you have 60 days to perfect an appeal to the Supreme Court. Now that is a procedural matter. So if you take a case to a lower court and it's found against you, you have that 60-day period. It's about the procedure and not about the substance. But if you don't act within the time frame that the procedure prescribes, then you could be divested of your rights, or as we lawyers tend to say, you could suffer latches for not acting on your right. And that's an example of procedure. Another example of procedure could be how pleadings are made to court. So the law provides in a civil procedure that one, when you have an issue, you must make a complaint to a court, and then the person against whom the complaint is made, who's a defendant, must file an answer, and then you will file another response, and then pleading will rest. And there's a 10-day period for any response between the parties concerned. Those are all examples of the procedures that should govern how you engage with the legal system. And so we divide those two into both the substantive law and the procedural law. And the final classification of law that we hope to share as we gradually wind down, also reminding you that if you want to participate on the program, you're free to do so on 0880-514-096 here on ELBC. So the final classification of law we have is basically international versus domestic or municipal law. So in the case of international law, if you just go by the nomenclature itself, you find that these are laws that regulate the behavior between nation states and how they engage. For example, maritime law. So you take Liberia, for example, we share the Kavala River with La Côte d'Ivoire, and how do nation states interact in regards to maritime rights and maritime processes. Those are the examples of international law, maritime law, for example. International humanitarian law, or laws that govern, how wars are fought. How do we interact as nation states? So all of these rules that determine how countries interact, human rights as well, between each other, not as an individual, but as states. These are examples of international law. And of course, we have what we term as domestic law, and domestic law being the laws that govern within a particular country. That makes it domestic or national laws. So all of the rules, all of the laws that we have in Liberia basically governing conduct. We have a caller down the line.
Hello.
Hello? I think we lost that caller. So as we're concluding, then we have the question of domestic or municipal law, which are national or laws that govern within a country. So, do we have a caller on the line?
Good. My name is Wellington Airplane. I'm calling from Tottenham Bay.
Go ahead, Wellington. You're live. Do you have a question?
Very good. We have an argument concerning domestic or national law and international law. Then we were talking about the strength of the both. When it comes to national law or domestic law, in the international law, which one is forceful? Which one has strength? Can you just explain that to us, please?
Very well noted, Wellington. We'll respond to that very shortly. Do we have another caller on the line? Hello?
Yes, sir. Good afternoon. How you doing?
Your name and where you call from?
Yeah, my name is Kanio Bai Gbala. I call from Single.
Okay. What's your concern?
Yeah, so I have a question. I'm thinking as to whether there is a difference between the doctrine of natural law and that of due process. Are there a difference between the two? Doctrine of natural law and due process, which you are talking about, so you can get to the next topic.
Thank you. Very well noted. Difference between doctrine of natural law and due process. Two questions there. So let's respond to these as we wind down now. We have a little over 8 minutes to conclude.